Welcome to our comprehensive exploration of the European Union's General Data Protection Regulation, or GDPR. In this video, we'll break down what GDPR is, why it was introduced, and how it impacts organizations and individuals both within and outside the EU. Whether you're a business owner, a privacy enthusiast, or just curious about data protection, this guide will help you understand the essentials of GDPR and its far-reaching influence on global data privacy standards. GDPR was adopted in April 2016 and became enforceable in May 2018. It was designed to harmonize data privacy laws across Europe, protect EU citizens' data, and reshape the way organizations approach data privacy. The regulation replaced the 1995 Data Protection Directive, reflecting the rapid technological changes and the growing importance of personal data in the digital age. Under GDPR, personal data refers to any information relating to an identified or identifiable natural person. This includes names, addresses, email addresses, identification numbers, location data, and even online identifiers like IP addresses. The regulation's broad definition ensures that a wide range of data is protected, reflecting the realities of our interconnected world. One of GDPR's most significant features is its broad territorial scope. The regulation applies not only to organizations established in the EU, but also to those outside the EU if they offer goods or services to, or monitor the behavior of, individuals in the EU. This means that even companies based in other continents must comply with GDPR if they handle EU residents' data. GDPR compliance is required for any organization, regardless of location, that processes personal data of individuals in the EU. This includes businesses, nonprofits, and even public authorities. The regulation's reach ensures that data protection is a global concern, not just a European one. Understand GDPR, it's important to know some key terms. A data subject is any individual whose personal data is processed. A controller determines the purposes and means of processing personal data, while a processor acts on behalf of the controller. These roles are central to how GDPR assigns responsibilities and obligations. GDPR requires that all processing of personal data must be based on a lawful ground. There are 6 lawful bases: consent, contract, legal obligation, vital interests, public task, and legitimate interests. Organizations must identify and document the appropriate basis for each processing activity, ensuring transparency and accountability. Consent is one of the most well-known lawful bases for processing. Under GDPR, consent must be freely given, specific, informed, and unambiguous. Organizations must make it easy for individuals to withdraw consent at any time, and they must keep records to demonstrate that valid consent was obtained. Processing is lawful if it's necessary for the performance of a contract with the data subject or to take steps at their request before entering into a contract. For example, an online retailer needs to process a customer's address to deliver a purchase. Organizations may process personal data if it's necessary to comply with a legal obligation. This could include tax reporting, employment laws, or other statutory requirements. The key is that the obligation must be rooted in EU or member state law. Processing is permitted if it's necessary to protect someone's vital interests, such as in a medical emergency. This lawful basis is generally used in life-or-death situations and is not intended for routine processing. Public authorities may process personal data if it's necessary for performing a task in the public interest or in the exercise of official authority. This basis is commonly used by government agencies and public bodies. Organizations may process data if it's necessary for their legitimate interests, provided these are not overridden by the interests or rights of the data subject. This basis requires a careful balancing test and is not available to public authorities. GDPR provides extra protections for special categories of personal data, such as health information, racial or ethnic origin, political opinions, and religious beliefs. Processing this data is generally prohibited unless specific conditions are met, such as explicit consent or substantial public interest. GDPR sets special rules for processing children's data. Parental consent is required for processing the personal data of children under 16, though member states may lower this age to 13. Organizations must make reasonable efforts to verify that consent is given by a parent or guardian. GDPR grants individuals a set of powerful rights over their personal data. These rights are designed to give people more control and transparency, ensuring that organizations handle data responsibly and fairly. Individuals have the right to be informed about the collection and use of their personal data. Organizations must provide clear, accessible privacy notices that explain what data is collected, why, and how it will be used. The right of access allows individuals to obtain confirmation that their data is being processed, access to their personal data, and other supplementary information. Organizations must respond to access requests within 1 month. Individuals can request that inaccurate or incomplete personal data be corrected. Organizations must respond promptly to these requests and make necessary updates without undue delay. Also known as the right to be forgotten, This right allows individuals to request the deletion of their personal data in certain circumstances, such as when the data is no longer necessary or consent is withdrawn. Individuals can ask organizations to restrict the processing of their data in certain situations, such as when the accuracy of the data is contested or the processing is unlawful. During restriction, data can only be stored, not used. This right allows individuals to obtain and reuse their personal data for their own purposes across different services. Organizations must provide data in a structured, commonly used, and machine-readable format. Individuals have the right to object to the processing of their personal data in certain circumstances, such as direct marketing. Organizations must stop processing unless they can demonstrate compelling legitimate grounds. GDPR provides safeguards for individuals against decisions made solely by automated means, including profiling that have legal or significant effects. Individuals have the right to obtain human intervention and to contest decisions. GDPR emphasizes transparency and accountability. Organizations must be open about how they process data and take responsibility for complying with the regulation. This includes keeping records, conducting impact assessments, and appointing data protection officers when required. GDPR requires organizations to implement data protection measures from the outset of any project. This means considering privacy at every stage, from planning to execution, and ensuring that only necessary data is processed. When processing is likely to result in a high risk to individuals' rights and freedoms, organizations must conduct a Data Protection Impact Assessment, or DPIA. This helps identify and minimize risks before processing begins. GDPR introduces strict rules for data breach notification. Organizations must report certain types of personal data breaches to the relevant supervisory authority within 72 hours, and in some cases, notify affected individuals as well. Some organizations are required to appoint a Data Protection Officer, or DPO. The DPO is responsible for overseeing data protection strategy and compliance, serving as a point of contact for authorities and data subjects. Each EU member state has a supervisory authority responsible for enforcing GDPR. These authorities provide guidance, handle complaints, and have the power to investigate and sanction organizations. The one-stop-shop mechanism allows organizations operating in multiple EU countries to deal with a single lead supervisory authority. This simplifies compliance and ensures consistent enforcement across the EU. GDPR restricts the transfer of personal data outside the EU unless adequate safeguards are in place. Mechanisms include adequacy decisions, standard contractual clauses, and binding corporate rules. GDPR gives supervisory authorities the power to impose significant fines for non-compliance, up to €20 million or 4% of annual global turnover, whichever is higher. These penalties are designed to ensure organizations take data protection seriously. Individuals have the right to lodge complaints with supervisory authorities and seek judicial remedies if their rights are violated. GDPR ensures that individuals have effective means to enforce their rights. GDPR encourages the development of codes of conduct to help organizations comply with the regulation. These codes provide practical guidance and can be approved by supervisory authorities. Certification mechanisms, seals, and marks can demonstrate compliance with GDPR. These voluntary tools help build trust with customers and show a commitment to data protection. Processors act on behalf of controllers and must follow their instructions. GDPR imposes direct obligations on processors, including security measures and record-keeping, and allows for joint liability in some cases. When two or more organizations jointly determine the purposes and means of processing, they are considered joint controllers. GDPR requires them to define their respective responsibilities transparently. Both controllers and processors must keep detailed records of processing activities. These records help demonstrate compliance and are available to supervisory authorities upon request. GDPR requires organizations to implement appropriate technical and organizational measures to ensure the security of personal data. This includes encryption, access controls, and regular testing of security practices. Data minimization is a core GDPR principle. Organizations should only collect and process the minimum amount of personal data necessary for their purposes, reducing risks and respecting individuals' privacy. Personal data should not be kept for longer than necessary. GDPR requires organizations to establish retention periods and securely delete or anonymize data when it's no longer needed. The accountability principle means organizations must not only comply with GDPR but also be able to demonstrate their compliance. This includes documentation, training, and regular reviews of data protection practices. GDPR has influenced data protection laws worldwide. Many countries have adopted similar frameworks, and organizations everywhere are raising their privacy standards to meet the expectations set by GDPR. Summary: the GDPR is a landmark regulation that has transformed the landscape of data protection. Its principles of transparency, accountability, and individual rights are now central to how organizations handle personal data. Understanding GDPR is essential for anyone involved in processing data, and its influence will continue to shape privacy practices for years to come.